Well, draw near, give your attention to Michelle Europe. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, Ms. Bannon.
SJC-10599, Commonwealth versus Lopez.
Ms. Peterson, good morning.
Good morning. I represent Jose Lopez, whose Fourth Amendment and Article 14 rights were violated when the police entered his motel room without a warrant, without exigent circumstances, without consent, for the purpose of retrieving contraband. The unidentified woman who came to the door and allegedly gave him, allowed him to enter, obviously had no actual authority.
Well, she was there, and so could you say she had apparent authority?
No, with
Why
all
not?
due respect.
Why not?
Well, I think the law on apparent authority has been made very clear in Massachusetts by Commonwealth versus Porter P.
But
And-
why do we even have to get there? Why doesn't she have actual authority? The rooms are small. They're all adults. They allowed her to open the door. They didn't say to her, don't open the door. They must have heard a knock because motel rooms aren't huge. And they allowed her to open the door, and then they allowed her to say, yes, you can come in.
Well, because under Porter P. and also Illinois versus Rodriguez, the only people who have actual authority as a third party are family members or
But
spouses.
how do we know she's
or-
a third party? She's an occupant of the room at 10 o'clock at night, which is
It's
quite
two
late.
rooms. Aren't there two rooms? Because there was a second
Well,
room.
he didn't know. The police officer didn't know there were two rooms when he opened the door.
No, I
but there
understand.
turned
But I'm
out
just
to be
saying there are two
Yes.
rooms, and so we don't know where the defendant was. The defendant could have been in the second room. She hears a knock. She opens
Right.
the door.
Right.
Well, and you see no distinction between search and entry. Is that
No, I
basically the
don't.
prim?
Right, I don't. But to answer your question, as he was on notice that she was not Victor by the fact when she came to the door, and it was a woman, that already put him on notice that the person he was looking for wasn't the person who was letting him into the room.
And she even acknowledged she didn't know who Victor was.
Exactly, which I think made it very clear that she couldn't even have actual authority to let him in.
Ms.
Now,
Peterson, I'm sorry, Justice Gans, go
Sorry.
ahead.
You had said when you began that the issue here is whether or not there was actual or apparent authority to allow an officer in for the purpose of conducting a search for a syringe. But is it your position that what he said is, may I search the room for a syringe, or simply may I enter?
My position is that he said he wanted to enter in order to retrieve a syringe. And I think that is a very, the distinction is hard to make there. It seems to me that under the facts, he would have had to search, because when he went into the room, he didn't know whether Victor was going to be there. He didn't just say, I would like to enter to see if Victor's there or to speak to Victor. He said, I want to enter to retrieve the syringe.
Let me just ask you about that. I may have the facts wrong. It was Victor who had pointed out to this officer that there was a syringe lying in the outer area, wasn't there?
The Victor had just said, would you come back? I have a syringe
Yes.
for you.
So, at least from that police officer's point of view, there was no reason to assume, one, that the syringe was in the room. It was lying outside.
Correct.
And two, does the record give us any indication of whether he had searched, the police officer had searched for the syringe?
No. In fact,
Does the record suggest that the police officer saw where the syringe was?
no.
But isn't it implicit in the record, though, that Victor has the syringe and he's going to retrieve it from Victor?
That's what I'm trying to find out, because I don't know whether you can assume either that the police officer thought that Victor had it, because at the time Victor said, come back and get it. It was
So he
lying
said,
outside.
Said, I have it for you, though, didn't he?
Well, he said, I have a syringe for you to pick up. And that apparently was customary, that that's what the police officer did. He would come from time to time with a
And
special
Victor would
little
give it
case.
to him.
And Victor would give it to him. But we don't know where Victor was when he gave it to the police officer.
No, so we don't have any reason to believe that he's taken it to his room.
Exactly. In
But
fact,
the
when-
second thing is that we don't have any reason to believe that it's contraband as to Victor. I mean, first of all, a syringe isn't in and of itself contraband, correct?
well, I think it's illegal to have a syringe.
Well, if you have a
It's-
prescription, it's not.
And not when there's an arrangement of which Victor knows that the police will come and pick up a syringe. The reason why that arrangement, I assume, is in place is for safety reasons. And in fact, the police, I gather, carry around a box for disposable hazardous waste, right?
Right.
And so we don't want hotels and motels tossing syringes into the garbage.
Right.
We really don't want that. So there's an arrangement. But from that police officer's point of view, he doesn't, it may not make any difference for search and seizure purposes, but he doesn't think that he's going in to retrieve, search for, identify, look for, or do anything else, quote, contraband. Because as to Victor, it's not contraband.
Correct. But what I'm suggesting is that since he didn't know whether Victor was in the room, and since, in fact, from what the unidentified woman had said, it was unlikely that he was in the room.
Wait a minute. I think we're trying to figure out something a little bit different than that.
I'm sorry.
When the police went to the motel the second time
Right.
to look for Victor, they went to the administration office.
Correct.
I take it Victor worked in the administration office?
He was the manager.
Okay, so there was certainly a possibility that the syringe might have even been in a safe or some kind of a vault in the administration room.
Correct.
There was no indication where the syringe was.
Correct.
Okay.
What is the past experience? Is there anything in the record that indicates what made the police believe that room 138 was Victor's room?
They were told that night, weren't they?
No, they were not told that night. In fact, they were not told what his room was. They were just told he was in his room. And the
Right.
police had been coming on a regular basis before and had known that that was Victor's room, just from what Victor
That's
had
in the
said.
record,
They'd never
that it was known to them that room
But what
138
was not,
Victor's
but,
room.
excuse me, the police had not been there for 3 months.
Right.
And it was a motel, and it was a motel where all kinds of nefarious things were going on, as well as a sting operation. So it was at least likely that he may not still have been in that room.
Ms. Peterson,
Can I-
let me ask you this. I haven't read the transcripts. I'm looking at the judge's findings of fact. And she says they were told by the night clerks, plural, that Victor was in his room, which the police understood to be room 138. What was the basis of the judge's finding that the police understood that 138 was his room? What's in the record?
What's in the record is that the police officer said, I had been told before on the
Okay.
previous times that I
Okay.
had been there that that was his room. But they had never seen him in that room or gone to that room.
I know that this is what the record says, but it seems very strange that the police said they hadn't been at the motel for 3 months, yet the officer on the scene was so exercised because he didn't want to jeopardize this big drug investigation that they were doing. So it was strange that they hadn't been there for 3 months when they were doing this.
Just these
big
two,
drug
just these two officers.
Well, but this officer seemed to indicate it was his, but it just seems strange.
Can I ask you, does it make any difference whether the officer was going to retrieve a syringe or simply wanted to talk to Victor? Does it make any difference at all to the analysis of
I
what
don't
the
think
intent
so.
of the officer was?
I don't think it does. I
So
think-
your issue is with him entering,
Correct.
asking to come in, and someone who he should have known didn't have authority allowing him in.
Correct.
And
I
whether or
think
not,
the case law in Massachusetts is very clear that there's no distinction between entering a room without a warrant and going in to search. I mean,
so
there,
there's no distinction between entering and going in for search. Okay.
And
And
what
what
do you-
about what about essentially entering for innocuous purposes rather than investigative purposes?
I don't think that distinction is made in Massachusetts case law either.
We recognize emergencies, not innocuous.
Yes.
This is not a
But this was not considered an emergency.
So what should the police have done?
What they should have done?
Yeah.
I think they could have knocked on the door, or they could have said to the woman, would you please go in and see if Victor is there and ask him to come out? I think that's what they could have done. They could have said, how come you're in this room? Are you renting this room? They, in fact, Illinois versus Rodriguez and Commonwealth versus Porter P. are very clear that the burden is on the police officer to ask questions until he ascertains some kind of a fact that allows him to believe the person has the authority to enter.
But both of those cases are search cases. And when you say it's very clear in Massachusetts law that you can't enter, just enter, what are you relying on?
I'm relying on, for instance, Commonwealth versus Ford, which says you may not enter for whatever purpose.
Okay.
I think Commonwealth versus Peters says the same thing. Commonwealth versus Rogers. And I think an interesting case is the Supreme Court case, Kylo, I don't know if that's how you pronounce it, where Justice Scalia was saying that every detail within a private home is protected from the prying eyes of the government by the Fourth Amendment. And I think that a police officer represents the prying eyes of the government. When he goes in to a private house or a private room or even a motel room, he can't help but see whatever is there. And if he sees evidence of a crime, he is obliged to report it. So what the Commonwealth is proposing here is a rule that would exempt the police from the Fourth Amendment if he has a purpose that is not to search, but will not protect the person who is in the room.
But in Kylo and in Peters, there was no consent. I'm not sure about Ford. Are you saying Ford there was anything approaching consent based on actual or apparent authority?
No, but I'm saying that what the case said was that the Fourth Amendment protects the inhabitants of Massachusetts from the police entering.
Well, I think that certainly that's clear in the absence of anything approaching consent. But the issue in this case is whether the same diligent inquiry required to conduct a search that's required in Porter P. is required simply to enter a premises. And you're saying it's the same.
Yes.
So you're saying that if a police officer knocks on the person's door and says, may I come in to speak with you, and the person says yes, the person will have to say, well, then can you please tell me what authority you have to allow me to in? Do you own the place? So he has to have that whole discussion on the doorstep.
Yes.
The same discussion he would have to have if he were saying, do you mind if I search your place?
Yes. I think that if the police officer comes to the front door, say, selling raffle tickets, and has no intention or no alleged intention of conducting a search, and somebody comes to the door and he wants to sell the ticket, and the woman or man says, come in, he is obliged to say, do you own this house? Is this your house? I think that the police officer is invested with that obligation.
Okay,
just
so
because
you're
he appears in a uniform.
So you're suggesting, I mean, in this case, the officer asked if he could come in. But you're suggesting even if an officer went up to the stairs, knocked on the door, and said, hello, can I speak to so-and-so? And the person said, well, why don't you come on in?
Right.
That also would trigger Fourth Amendment considerations.
I'm saying that it does. I'm saying that if you don't say that, that gives the police too many ways to evade the Fourth Amendment.
But does it make any difference here that there was an appointment to meet Victor? Victor called the police and said, come and pick this up. And they for some reason, for the reasons apparent on the record, they couldn't do it right away. They had to come back. But Victor was expecting them to come back.
Well, A, we don't know when he was expecting them to come back. He was off. The police were attending to an emergency. And B, the appointment wasn't made to meet Victor at his room 138, because in fact Victor didn't even live there at that time. So there
Ms.
was
Peterson,
I'm sorry.
Finish your answer to Justice Spina.
So I don't think it can qualify as an appointment to go to room 138 to pick it up. It was just a vague, we'll be back at some time and we'll look for you. But he couldn't have made an appointment to meet at that particular motel room because he had rented it to somebody else.
Let me ask you this. In her dissent, Justice Lenk is focusing on authority.
On what?
Authority. The woman's authority to let, and she, I think, correctly says, we look at what's reasonable in the circumstances, but she says the doctrine of apparent authority, and she's going on apparent authority. I take it there was no actual authority established.
The Commonwealth conceded that there was no actual
Okay.
authority.
Comes when the third does not have actual, but where it was objectively reasonable, I'm reading from the opinion, objectively reasonable time for the police to have believed she did. Okay, so that's the test, and do you accept that test?
I'm sorry, I don't understand what you said.
I'm reading from the dissent,
Right.
and she's saying the law for apparent authority,
Right.
that it is proper for the police to enter when somebody has apparent authority, and if we are now looking post hoc to see whether the police made the correct decision, it is whether it is objectively reasonable at the time for the police to have believed that she did. Do you agree with that?
I would like to add to that from Commonwealth versus Porter P.
Okay, that may be under Massachusetts because she's under federal law, but let me ask you about the next sentence. The focus of the inquiry remains unchanged, and what matters, this is Justice Lenk, is what the officer knew about the relationship between the third-party consenter and the premises or effect sought to be inspected. Now, that's in a search context because nobody's separating entry from search. And she then cites to Illinois against Rodriguez. If I look at Illinois against Rodriguez, is that correct? I.e., we have to look at what the police officer knew about the relationship between the woman and Victor?
No, I think it's the relationship between the woman and the room that she was in. I mean, it's conceivable, for instance, and in fact it was the case, that Victor no longer lived there. Say the woman had rented it, was paying rent for that room, and it was her room. She could have given consent to the police officer to enter.
Okay. Thank you, Ms. Peterson. Good morning, Ms. Celia.
Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth.
Would you like to just focus on that piece? Is Justice Lenk correct about that's what we have to look at if you're going on the basis of apparent authority?
It would be between the relationship between the woman and the room. And I think that, for one, is this woman could have had actual authority. The Commonwealth didn't have the evidence to show that. Presumably.
So have you or haven't you conceded that she didn't have actual authority?
Right, based on.
You have to prove that she has.
Right. I'm saying, but the inquiry regarding we had to know a lot about her relationship with Victor. In actuality, she could have actually had the authority to let them in. We couldn't prove that, so that's why we're then going on apparent authority.
Well, then that's out of the case because it's your burden, right?
But I think it goes to your question about her relationship to the room as opposed to her relationship to Victor.
No. Justice Lenk says, and I'm sorry if I misstated, the relationship between the third-party consenter and the premises or effects to be inspected.
It would be at the time that the officer's there, whether this woman could go to who answered the door, whether he could reasonably think that she could, just for the limited purpose, allow him to cross the threshold and enter.
But we're here under apparent authority at this point, right?
Yes, and that's whether it is reasonable for the officer to think that when he knocked on the door and said police and a woman answered the door, whether or not he could think that she had the authority to just let him enter. That's it, cross the threshold.
Right.
And
the police are proceeding on the basis that this is Victor's room. No question about that, correct? They're looking for Victor. They go to 138 because they believe this is Victor's room.
That is correct. That's the reason they originally went to the manager's office.
No, yeah.
And just to respond to the basis for the judge to find that someone inside the office said Victor's in his room. And the officers, whenever the officers, they had a practice for a period of time of checking the logs daily. And at that time, Victor would represent that his room was 138. That And in just regards to my sisters,
I'm sorry, just say that again. They had a practice of what?
going and checking the logs, because this was under investigation. This was part of their routine. They would literally check who stayed at that hotel every night.
That's in the record?
That is correct.
Okay.
And they had ended that practice 3 months ago. They didn't end going to the Ocean Lodge Motel because that's evident that they went there to help out for, alleged robbery or prostitution. And you can see that. So it was they stopped the practice of going and checking the logs. It wasn't clear, but it may be due to the federal investigation that was going on at the time. It's not quite clear. But I think it's when they knocked on the door and she opened the door, whether or not she had the authority to let them enter. And I think that if you look at this court's opinion in Porter P., it's focused on the joint access. And I think in some ways, she's already established she has joint access, but going to the door and...
Does it mean that somebody he's living there, right? It means you can't have a guest because it's a hotel room?
No, but she has what I'm saying is she has access to the door.
Oh, she has access to the door. Does her sort of guests?
I'm misunderstanding you.
Well, the fact that she opens the door, she has access to the door, but a guest can open the door?
That's correct, and the guest could have the authority to let the officer in. If you're at a friend's house and you're sitting on the couch and the doorbell rings, you don't get up and answer it.
Sure you do.
Unless your friend says, go answer the door.
Well, go answer the door doesn't mean go answer the door and let somebody in.
Well, I think at that point, why else would you be able to answer the door?
Because you want to see who it is.
Correct. And at that point, when the police officer says...
Are you suggesting that, doesn't that vitiate apparent authority? That means that anybody who opens the door, as I understand your argument, as anybody who opens the door in a space, which is protected under the Fourth Amendment, is presumed, because they opened the door, to have the right to let somebody in?
I think it would depend on different factors, including...
What are the different factors?
Well, I think that, like in here, whether or not the woman projects an aura of authority in the fact that she was the only person who was there in the room, that it was 10 o'clock at night.
An aura of authority. I thought the officer said she was stoned, looked like a deer in the headlights, didn't know who Victor was. What aura of authority do we have here?
I respectfully, there was no evidence that she was stoned. He said that she looked at a deer in the headlights and may have been intoxicated. But I think that doesn't. I think that could be a natural reaction to a police officer coming.
What's the basis of saying if somebody, quote, projects an aura of authority, that they are presumed to have authority? What's the citation for that?
What?
Where's the case that says that?
I think I cited it in my brief. The case, obviously this is first impression of this court, but in citing the federal cases in my brief, there was a case right on point that says, and I think it might be Commonwealth versus Rosario, which was actually cited in the court's brief, in the court's opinion in Porter P. And I think that here was an adult woman. There was testimony that she was a little stunned, but I think that could be a natural reaction to to a police officer being there. This court is.
She doesn't know who's going to open the door. She has a knock. She doesn't know it's the police officer.
Correct, but at that point, the officer says, is Victor there? And she doesn't say no, and she doesn't even give him a reply to think that he may not be there. It was, I don't know, and then his next statement to her was, he asked me to get a needle. He didn't say, I'm here to search, I'm here to come get a needle. It was, I'm trying to find information about a needle. And then at that point, he says, can I come in? And she says, yes, sure. The officer crosses the threshold, and at that point, he looks to the right into the room that was adjoining. There were very small rooms. The one that the woman was...
Now we're in the limit. Let me just go to when he enters. So the basis that you are saying is that a person opens the door.
Correct.
Officer doesn't know why the person opens the door. And if they project an aura of authority, the police can enter.
I think that the factors. Was there anybody else objecting? Say, you can't open the door. If you said, can I?
Wait a minute. She opened the door. It's not one room. It's two rooms. So I can be on the telephone in the second room. I can say to my friend, please open the door and see who it is. It might be the cleaning woman. It could be anybody. And so the police don't know that. I'm thinking of it from a police officer's point of view.
Correct.
Right? All that they know is that she opens the door
Correct.
in a room that they think, in which they think Victor is living,
Correct.
and she projects an aura of authority, although the defendant would question that, and they can then enter?
Correct. I mean, I think it's looking, and when I say that, it's looking at the factors that were present for the police officer at the time to think that this woman could let him enter. It was 10 o'clock at night, obviously they're either there because...
We have a different rule for night and day?
No, but I think that if someone's there at a certain hour, that they're supposed to be there.
83 a.m., 10 o'clock is not, seems to me, not a lot of difference between 7 and 10 in a hotel room.
Well, depending on your that hours that one keeps, but and also these are rooms. These are joining rooms. They were right next to each other. There were 8, and there was a door that went into the next room. 8 by 10, very small rooms. When the officer said, giving her information, she was giving lucid answers. That he testified she understood what he was saying, and that when the officer said, "Can I come in?" she didn't look back to the defendants who were sitting not too far away on the bed. There was a lot of marijuana on that bed. And I think at that point, an officer could think that the woman could let him in.
Wait a minute. You mean after he finds something illegal, he can go back and think that the woman could let him in?
No, at the point that he's sitting at the threshold asking her, "Can I come in?"
He doesn't know there's a lot of marijuana on the bed in the second room.
No, but what I'm saying is that there were people that were sitting on the bed that wasn't very far away, that the woman, when the officer said, "Can I come in?" she didn't look back to them. She didn't say, if you invited a friend over, see who it is. Your friend, if someone said, "Hey, someone wants to come in," your friend would say, "Hey, someone wants to come
maybe
in."
No, but assuming she doesn't say, "Hey, can I let him in?" doesn't give her the authority to let them in.
It's what it appears to the officer of whether or not she
No,
could let.
it's not the officer. It's objective. It's objective, not the officer. Objective.
Right. Would a reasonable person in the officer's situation with the facts known to the officer, would he think not wanting to go into search, just wanting to cross the threshold? And I think that in this court's opinion in Porter P., they were talking about, quoting Georgia v. Randolph, talking about commonly held understanding about authority of co-inhabitants, talking about customary understanding. And I think...
Let me ask you this, Ms. Senior. It seems to me that the majority opinion in the appeals court, the critical thing, they spend a lot of time on the intent of the officer.
Correct.
And the critical thing is that viewed objectively, I'm quoting,
Correct.
these circumstances, and they've essentially run down the circumstances, indicate that Officer DeSimone do not reasonably indicate that Officer DeSimone intended to conduct a search, thus obviating any need to second-guess the women's consent to enter. Under our case law, if an officer does not intend to conduct a search, is that the end of the matter?
I guess I'm a little, don't understand the question. In what context?
Is it the same test?
It's
In other words, if the officer is there just to ask some questions or there to try to get inside to see what he can see?
Sell tickets. The officer's there selling tickets to a raffle. Perfectly permissible activity. Knocks on the door and says, "Can I come in?" with somebody who doesn't have the authority to let him in or her in. It seems to me that the majority opinion is focusing on the officer's intent.
I think it does inform the reasonableness of what the officer in its...
Well, then let me ask you, do you agree with this statement? The evidence that the appeals court relies on about the officer's intent, and I'm sure you know it,
Right.
The officer approached the room reasonably thinking Victor was in there, so on and so forth. Viewed objectively, these circumstances do not reasonably indicate, so we've got the objective, we've got the reasonable, that Officer DeSimone intended to conduct a search, thus obviating any need to second-guess the woman's consent to enter.
I agree with that.
So for Fourth Amendment and Article 12 purposes, we looked to whether there was some ulterior motive, it was what his intent was.
Well, I think that it also shows then his it manifests by his questioning to her and what he says to her, and that when he says, "Is Victor there?" and she says, "I don't know," not saying no. He still doesn't, it's not concrete that Victor's not in there. And he says, "He asked me to get a needle." And she says, "Yeah, sure." I mean, obviously he's showing that he had no intent to search the place. And then he asked, "Can I come in?" And she says, "Yes." And
But again, what I'm trying to get you to understand the differences. One is what's objectively reasonable. If somebody goes to a hotel room in a ward house or anything else, and all of the majority opinion turns on the officer's intent.
that is correct. I think it's a factor that you can.
They're not using it as a factor. They're using it as the explanation for why it was reasonable. It's the officer's intent, and I'm asking you, I don't see citations other than to Commonwealth Maloney, which I haven't looked at, that under our jurisprudence, the officer's intent is determinative of what's objectively reasonable.
Well, the only thing I can think of is in the search and seizure pat frisk situations, and you say
no, we're not talking about pat frisk.
Well, just in terms of the intent, and I mean, there's nothing that
I thought we had quite carefully not adopted that line of cases.
That the subjective intent of the officer is irrelevant. That's what he's saying. Because it is whether or not X, Y, and Z gave the officer fear for safety or a reasonable suspicion,
sure.
And that that's very clear. But I think that but that has to be, does X, Y, and Z equal fear for safety? Where this is actually, was it reasonable to the officer looking at the facts he knew? And I think in some ways then it informs whether or not he should have asked more questions or could have just relied on the adult woman who came to the motel room.
If I could step back and just to make sure I understand. The officer apparently said, "May I come in?"
Correct.
I assume your position is that the diligent inquiry required with regard to a search is not required when all he's asking is to come in.
That is correct.
But I assume you're also saying that there must be some reasonableness on the part with regard to her capacity to allow him to enter.
That is correct.
Now, are you saying that if the police officer had said, I would like to search the room for a syringe, that the same information would be sufficient to justify his belief in the apparent authority of this woman to give consent, or that more would be required?
I think in that way more would be required for him, because then it would be, what he then searches as part of the room, whether she has the authority over that. But coming to the door, and is what appears to him to have the authority to just allow him to enter. And if this court has no further questions, I'll rest on my brief.
Thank you, Ms. Celia.
And Your Honor, thank you for the service to the Commonwealth.